China says that since it declared its 9-dash claim in 1947, it predates and so is unbound by the United Nations Convention on the Law of the Sea, and further noted that no country immediately protested. Thus, they argue that it has at least a nominal historical authority over the water. However, in 1982 UNCLOS, several countries rejected China's claim of historical sovereignty over the dotted lines and does not exist in the 1982 UNCLOS ruling. Any historical sovereignty claim must be able to show a nation has had a peaceful and long-lasting rule over an area, and it must be acknowledged by nations based on internationally accepted laws at that time. Although the Chinese Kuomintang government first introduced the 11-line claim in 1947, which was later reduced to 9-lines, it was only in May 7, 2009 that China issued an official note concerning the claim, formally bringing the 9-line map to global attention. However, Chinese assertion based on historical claims must be substantiated by a clear historic title. It should be noted that under public international law, historical claims are not historical titles and could not be a basis for acquiring a territory. Under international law, the modes of acquiring a territory are discovery, effective occupation, prescription, cession, and accretion. Also, under public international law, for a historical claim to mature into a historical title, a mere showing of long usage is not enough. China has neither shown any of admissible historic title nor exhibited legal acts of acquiring their claims based on the internationally accepted rules of law and UNCLOS provisions. In addition, other criteria have to be satisfied, such as that the usage must be open, continuous, adverse, or, in the concept of an owner, peaceful and acquiesced by other states. Mere silence by other states to one's claim is not acquiescence under international law. Acquiescence must be affirmative, such that other states recognize such claim as a right on the part of the claimant, that other states ought to respect as a matter of duty. There is no indication that the international community have acquiesced to China's so-called historical claim. On Chinese contention that Chinese fishermen have used the South China Sea for a long time, fishing right is not a mode of acquiring sovereignty, or even sovereign rights, over an area, but merely an economic activity done by individuals or private entities. Neither could it be construed that the act of fishing by Chinese fishermen is a sovereign act of a state, nor can be considered as a display of state authority. In relation to name-giving and maps, name-giving, or names in general, and placing of land features on maps, these are also not bases in determining sovereignty. In international case law relating to questions of sovereignty and ownership of land features, names and maps are not significant factors in the determination of international tribunals' determination of sovereignty. On the other hand, records show that Philippines has exercised both effective occupation and effective jurisdiction over its claims since the American administration. Scarborough Shoal entered Philippine jurisprudence in 1916 when the Philippine Supreme Court decided a case involving a shipwreck within the shoal's proximity. The shipwreck predates China's 1935 claim. In 1957, the Philippine government conducted an oceanographic survey of the area, and together with the U.S. Navy force based in the then U.S. Naval Base Subic Bay in Zambales, used the area as an impact range for defense purposes. In 1965, a small lighthouse was built and operated by the military. In the same year, an 8.3-meter high flagpole flying a Philippine flag was raised. In 1992, the Philippine Navy rehabilitated the lighthouse and reported it to the International Maritime Organization for publication in the list of lights. The Philippines Department of Environment and Natural Resources, together with the University of the Philippines, has also been conducting scientific, topographic, and marine studies in the shoal. In regards to Philippines' Spratlys claims, in 1946, Vice President Elpidio Quirino reiterated that the Southern Islands, the forerunner name for Calayan, as part of the Philippines. In May 1956, Thomas Cloma, a Filipino explorer and businessman, declared the founding of the new municipality he called Calayan, or Freedom Land, and claimed about 50 features of the Spratlys group but ceded them to the Philippine government a few months later. The Philippines sent troops to the Spratlys group for the first time in 1968. By the end of the 1970s, the Philippines had occupied a total of 8 islands and 2 reefs. To further its claim on the island group, the Philippine government incorporated the Calayan group into Palawan province as a municipality in April 1972, and claimed in 1974 that its location rendered it strategically important to Philippine national security. In March 1976, the late President Marcos issued the Letter of Instruction No. 176, organizing the AFP Western Command based in Palawan, in response to the heightening conflict of interest in the region, and to abate any untoward incident. In 1978, the Philippine Presidential Decree No. 1599, underscored the fact that Calayan is within the Philippine 200-mile exclusive economic zone. Elections have been held on Calayan Islands since 1980, when Mr. Alona Heraldo was elected as the first municipal mayor. Manila-based Smart Telecommunications established a cell site, connected to its main network via VSAT on the island in 2005. Most recently in 2009, when the Philippines passed an amended archipelagic baselines law that is fully consistent with international laws, Scarborough Shoal and Spratlys were classified under the regime of islands consistent with the international laws. Moreover, Philippine control of the waters within its territories in Scarborough and Spratlys is affected by frequent patrols and policing of these waters for decades without protest from any other country claimants, including arrests of Chinese, Vietnamese, Malaysian and Taiwanese fishermen illegally fishing in Philippine jurisdiction or using illegal fishing methods in its waters. China only began occupying features by mid-1980s, causing the ASEAN plan of jointly developing the area to halt. The most controversial occupation of China is the Philippine-controlled Mischief Reef in 1995,